to the SDL. I'm Mitch Hayes.
And I'm Greg Vinogradsky.
And on today's episode, we want to give you an update as to what's going on with the New Jersey courts, especially as they're looking to bring back jury trials. And New Jersey has just laid out some guidelines and a roadmap that they intend to follow in some select counties. Greg, why don't you give everyone an update as to what's going on?
Yeah, so New Jersey, laid out the initial reopening plan, and we expect it to change. And this could be what we see in other states that have been shut down. So it's limited to a few counties. It's typically going to be in some of the counties with the lower dockets, so that they can slowly reopen and we can see kind of what works and what doesn't work. So initially, you're not going to see 100 jurors in a room before anything even happens and there's any action, right? So there's going to be pre-screening. I'm sure there's going to be questions about contacts, illnesses, that kind of thing, to make sure that the person is even safe right off the bat, and if there's anything that would disqualify them initially. And once that's done, the voir dire process for the attorney and the juror will start, and that'll all be remote as well.
So I think it's good. I think it's good that the court has advanced technology in this respect, that they want to have jurors remote in for safeguard purposes. But I think it's also going to get more participation out of the jurors. There's not going to be 100+ people in the room, like you were just saying, trying to get out of jury duty. They're going to be listening as possibly a distraction from whatever's going on at home, and be more focused on the case and possibly want to participate more in the process. So I think this might be a potential way of the future that you'll see a pre-screening of jurors done, and we'll see how it works out in New Jersey.
Yeah, I mean, I agree. I think that, nobody likes jury duty. And, there's nothing really more frustrating, though, than seeing an uninterested jury when you're trying to, litigate your case or trying to pick your jury pool. And so I think you're right, that this will create a sense of relaxation and possibly more participation and a necessary distraction, frankly, from what's going on at home and on the news. And so, that's the first step. And the jurors are gonna, once they're in the courtroom and the juries and the trial start, it'll be very slow. It's going to be one trial for civil, one for criminal in that particular county at a time. And there's still some uncertainty as to how they're going to choose these trials. Are they going to try to conference them first? Are they going to pick the oldest dockets first and run that way? Or are they going to pick some of the simpler cases and try to pick them off first? So I think that that's just another layer of uncertainty that the courts are going to ultimately deal with once this reopening begins.
Yeah, we're going to have to get creative still. We've had to be creative since the pandemic started, but still we're going to have to keep with that creative legal mind that we all have going. We don't know when we're going to be listed for trial. Even if we had a case on right when the pandemic started and the court shut down in mid-March, we don't know if we're going to be listed first on the docket in September. Those decisions still need to be made by the courts and relayed to us. But I think what we can do as a big part is get creative. Binding high-low agreements is one topic that Chris Fusco at our firm wrote about, and you can find out a link to his article in our comments section below. And what he was talking about was getting with your adversary, getting with the clients as a way to achieve a more efficient and faster litigation, using the judges that are just hearing motions or other arguments besides doing trials, and have them hear bench trials. They could be civil or criminal judges. Have them hear the bench trials. They won't know what the outcomes are, what the high-low parameters are. They'll decide the case more efficient, less people in the courtroom, safer, and we'll get the results in a quicker manner than having to wait. We also should continue to do mediations and figure out good ways to work with our adversaries in order to get through this.
Yeah, I know, we've been trying to mediate and try to settle as much as possible. Plaintiff counsels have been motivated to get things done. It seems like everybody's trying to work towards one common goal for once, to try to resolve things as quickly and efficiently as possible for everybody. And I love that idea of the high-low agreement, because it means that, your case is coming up to the trial, all the discovery is done, you have all your ducks in order, and you're just waiting for the hammer to fall, basically, for one side or the other. So this is a good way to mitigate things for your client on the defense side while trying to move your case on the plaintiff's end as well.
So as Jersey continues to reopen the court system, as the roadmap and guidelines develop, we'll make sure to keep you updated. We'll let you know how the case selection process has been going, and where the pitfalls have been, and where the good parts of this reopening plan have been. Make sure to keep following us on our YouTube channel, subscribe to it, our other social medias. And until then, take care.